everyone, and thank you for joining us for today's session, where we will be looking at mortgage fraud, negligence, and a number of issues concerning conflicts of interest and identity fraud. My name is Stephen Smith, and as always, I'm delighted to be joined by Ian Quayle and my colleague, Robert Kelly. Firstly, an apology, as James Balance of Maitland Chambers is unable to join us for the session today due to illness, so we wish him and his family well on that. But Ian, Robert, good morning. Welcome to a new set of webinars this year.
Morning.
Before I hand over to Ian, I'd just like to go over a few items so you know how to participate in today's event. You're listening in through your computer system by default, your speaker system there. If you would like to join in by the telephone, you can do just by selecting the telephone option in the audio pane, and the dial-in information will be displayed. It is toll-free, so no additional cost to the usual charge you may pay. You will have the opportunity to submit text questions to Ian by typing your questions into the questions pane of the control panel. You can send any questions at any time during the presentation, and we'll collect these and address them during a dedicated Q&A session at the end of the presentation. You can also raise your hand during the presentation if you're having any difficulties with sound or other technical issues. Please do get in touch and we'll be able to try and resolve those if we're able. Finally, we've included some notes for today's session in the handout section of your control panel. Again, if you're having any issues accessing these notes, please get in touch, because we'd be very happy to share these with you to support the presentation that Ian is giving. Anyway, without further ado, I will pass over to Ian for the main part of today's presentation. Thanks, Ian.
Thank you, Stephen. Thank you, Robert. Thanks, everyone, for coming along today. Yes, it's sad about James. Unfortunately, his little boy's contracted COVID, and I think he's quite poorly. So best of British to him and to James and family. And apologies to everyone for the fact that he won't be attending. Yeah, as Stephen mentioned, what we're going to be doing in this first webinar of the year is just sort of reviewing some issues with regard to fraud, mortgage fraud, identity fraud, and lots of other issues sort of surrounding. I thought it would be useful to sort of revisit Dreamvar and Purrunsing, and to look at Grondona as well, and that was really one of the purposes of having James along, was to give his insight into those decisions. And I'm fortunate in that James has written an article on this issue, so I've got his views both from him directly and indirectly via his notes, which I'll share with you if that's possible. So hopefully you're all sitting comfortably, all sort of refreshed after the holidays, all forgotten about now. And what we're going to be doing is exploring a number of things. Questions, as Stephen mentions, happy to take as we progress, or happy to take via email afterwards. Again, if Stephen and Robert are happy with this, I'm more than delighted to share any sort of responses or any questions that I get from people, provided they're prepared to allow me to share whatever is sent out to me. So hopefully you're sitting comfortably, and hopefully we can start. Property fraud and issues associated with property fraud are a fundamental problem in the conveyancing process. Just recently in November there, we all saw the news about the unfortunate chap in Luton returning home to his property and finding that someone was there. Other cases sort of abandoned, you'll see in sort of regional press and sort of headline news in the likes of today's Conveyance and the Law Society Gazette. So the problems that Purrunsing and Dreamvar sort of highlighted are with us, and my view is will remain with us indefinitely. I remember years ago having the misfortune of having to deal with a chap that had been to prison for property fraud, and he was attempting to buy some commercial property, and I wisely refused to act. But one of the things that came to my attention in our meeting was how clever this guy was, and I'm frequently reminded of his intellectual skills, his IT skills, etc., and it was frightening, to be honest with you. Had he put his skills and knowledge to good purposes, then I'm sure he'd be very successful. What he's doing now, I don't know. Where he is, I don't know, fortunately. But if he's put his skills to bad purposes, then heaven help us, to be honest with you. So, what types of fraud are being encountered currently? What's the spectrum of fraud, and why are conveyancers targeted? Well, types of fraud that are being encountered, the same old sort of problems are manifesting themselves in different forms throughout. Identity fraud, fraud relating to IT and opportunities to intercept communication and to change communication to the advantage of fraudsters are commonplace. Identity fraud, commonplace as far as fraud itself is concerned. We don't know just how much fraud is currently being undertaken. We only find out when these fraudulent schemes are brought to book at some point in the future. So again, we haven't seen, if there is to be a flood of claims relating to property fraud courtesy of lockdown, we haven't seen them yet. Just as we haven't seen negligence claims that perhaps are facing us as a consequence of work that's done or not done during lockdown, we haven't seen yet. It's too early. The spectrum of fraud is sort of ever widening as we get more and more technically savvy with regard to the conveyancing process. Fraudsters are onto us. It's sort of like the lions chasing the zebras, isn't it? Really, in Africa, there, you know, that they're always sort of planning and scheming, etc. And as we get more sophisticated, I'm fairly confident they do. Why are conveyancers targeted? Well, we know why conveyancers are targeted. The opportunity to buy property, remortgage property, utilize client accounts is just a greater an opportunity to fraudsters to wash dirty money than it ever was. So the problem, the issues that we've seen in the past are just as much present today as they ever have been. I mentioned that then leads to a risk of negligence claims. It leads to professional negligence claims being brought by the lay client and lenders, as Steve alluded to in his presentation focuses in on, and it also, of course, leads to client complaints. If we're acting for an innocent victim that's been subject to fraud perpetrated by another, you can imagine that our client is not going to be a particularly happy teddy bear, no matter what we have or haven't done. And therefore, it's incumbent on us as individuals, as lawyers, as professionals working in the conveyancing marketplace to be alive to fraud, to be wary of it, and to educate our clients with regard to risk. Again, in the notes I mentioned what criminals will target, what are the sort of soft options to our lions that are hunting us out in the Serengeti. Sole owners, especially of unmortgaged properties, absent owners, especially landlords, owners who are in hospital or care homes, owners who have died, their estates, owners living overseas, and owners that have got a significant amount of equity in their property are all sort of super targets for fraudsters. And as far as lenders are concerned, again, lenders are regarded by fraudsters as fair game. You know, it's not an individual sustaining loss if a lender takes a hit. And of course, the problem with regard to lenders is if a lender does take a hit, they will look to us, or more accurately, our professional indemnity policies, in order to recover any loss that's been sustained. So the marketplace is the same as it ever was. The risk and vulnerability is the same as it ever was. Are there things that we can do to protect ourselves? Are there lessons that have been learned as a consequence of the cases that I've mentioned and as a consequence of changes in and development in connection with conveyancing practice? Let's just have a look at some points there, really starting with identity fraud as our starting point. As far as identity fraud is concerned, remember that it is very easy, if we're tracking a client or a potential party that is going to be subject to fraud, to find out about their circumstances and situations. Facebook, other social media, even LinkedIn, it gives an opportunity for fraudsters to find out about potential targets. It's not for us to warn our clients about the bigger picture concerning the dangers of social media, but I think it's important to be aware of the fact that getting information that enables us to go to the next level with regard to identity fraud is out there already. The cat is already out of the bag in that regard. It is therefore even more important to be vigilant when we're onboarding clients. And one of the key messages today is to be vigilant throughout the transaction, to be aware that our clients aren't necessarily our best friends, to be aware of the fact that new clients might be coming to us for a particular reason that may be unhealthy. Understanding and appreciating that compliance issues, money laundering issues, best practice issues are not tick box exercises. One of the things, again, I want to highlight is the idea that as you are experienced conveyancers, as you become more experienced, you tend to develop what's called a sniff test. You know, that something looks wrong, and some things that are said to you in isolation don't necessarily cause a problem, but the cumulative effect does. And I think that's important. And one of the key points, I think, is not just thinking about client identity issues when we're onboarding clients, then thinking that because that exercise has been undertaken successfully, we don't have to worry about anything else relating to client identity as the transaction progresses. I also mention in the notes that as far as fraud is concerned, the Land Registry continue to take a fairly active part in preventing identity fraud, because identity fraud, generally speaking, creates problems for them with regard to indemnity claims or the risk of indemnity claims. And we'll touch on the role of the Land Registry and some of the ideas that the Land Registry are putting forward and some of the facilities that the Land Registry have provided that we can talk to our clients about to prevent fraud. And here's another point that I want to make to you this morning. One of the things when I'm talking to firms about acquiring new business and generating new business for clients is trying to identify opportunities to reach out to clients that we've acted for in the past, or potentially new clients that might have made an inquiry of us in the past but haven't used us as yet. Why not send out a newsletter to clients, and why not highlight the risk of identity fraud? So I was doing a little bit of work with a firm in November last year, and the problem with regard to the Luton property that hit the headlines all of a sudden was not only in the newspapers but also on TV. And they very quickly created a newsletter that was emailed out in an e-shot, emailed out to clients old and new, advising them of this, advising how it happened, and advising as to what steps and measures could be taken in order to prevent that sort of thing happening to the clients of the firm or prospective clients of the firm. And I thought that's a good idea. I always encourage communication with clients old and new as a means of ensuring that you're in the shop window in case new business comes along. And you know, a horror story with regard to identity fraud is a good way of at least getting the client to open the email and having a look at it. And they might be grateful to you for the advice that you're giving or the suggestions that you're making, which can't do anything other than be good as far as your firm is concerned. So again, I think it's important to be aware of the fact that identity fraud is very much alive and well, that identity fraud can create problems and isn't just a one-stop issue for us at the start of a conveyancing transaction. So fear and awareness, I think, is important. Client awareness, of course, critical. And the bad news and good news that I mentioned on the slide here is the bad news is that fraud is out there. The good news is it gives us an opportunity to provide added value to our clients about, hey, there's this nasty problem sitting out there, but we've got some ideas and some solutions that may ensure that you're not subject to this fraud. Or in highlighting awareness for clients with regard to the problem, we can ascertain their sort of strategies, their attitude with regard to risk. So if we've got a client that's particularly jumpy or concerned about identity fraud or seller identity fraud or other aspects of fraud, we can explain to the clients, one, their vulnerabilities. So we're not really sending out a good message with regard to that, but explaining where there are vulnerabilities that can be protected, just what that protection is. At that point, Robert Kelly from Stewart Title, Business Development Manager. Robert, you have a product that I was impressed with when you first told me about it, and that you're still sort of maintaining on your book, as it were, and that's a product that sort of deals specifically with seller identity fraud. And I wonder if you could just share with delegates that are attending today a little bit about that product and a little bit about its usefulness in the context of the circumstances that I've just mentioned.
Yes, certainly, Ian. After the Dreamvar case in particular, we had a lot of clients ask us whether there were any policies that could be prepared. So we worked with them and produced what we call the fraud solution policy. And the idea here is it's to protect you. It's not to remove your obligations to try and find out the identity of a seller. But of course, the real problem of Dreamvar is that it makes you as the buyer's solicitor responsible for the bad workmanship or sometimes even fraud and collusion of the seller's solicitor. So our policy is available to buyers and to lenders and provides cover where there's been fraud, impersonation or duress of the seller. And one particular factor of it, which we've done, again, having talked to clients, is we've expressly waived the right of subrogation against the buyer's lawyer. So it does provide protection for law firms as well. It's available for properties. They don't have to be occupied. They don't have to be encumbered. So it does cover majority of properties that come on the market. The only limitation is cover is limited to £1 million. But if you're lucky enough to be selling a house of more than £1 million or buying a house of more than £1 million, it can be bought to cover that amount. And whilst it's always difficult to encourage clients to buy title insurance, in this case, the important thing is it's probably the only policy we sell where you're looking at total wipeout if the risk occurs. And therefore great protection for you and for lenders, and because of the waiver of subrogation for the law firm as well.
That's the point that I think that's really interesting, Robert. The idea that this, we're selling this policy to the client, but in reality, yes, the client derives benefit, but so does the conveyancing firm and so does the lender. So particularly in Dreamvar and in Purrunsing and in Grondona to an extent, all those firms could have been protected if seller identity fraud was an issue and the buyer's lawyers or the buyer client was sustaining loss. So it seems to me,
and the other advantage for clients is if they come against your PI policy, which would be the natural route in those cases, they need to prove negligence. In this case, they merely need to show there has been a loss. So the protection for the client, the payout is going to be much quicker in any event. So there is great advantage for the buyer as well as for the law firm.
And were you saying there, Robert, that if you were buying a property in excess of £1 million, there is a policy, there wouldn't be a standard policy, but you could insure against a greater value, could you or not?
No, we couldn't insure. You could take out a policy up to £1 million, so it would give you at least £1 million back of your purchase monies, unfortunately, but the rest wouldn't be covered. That's because at the moment we need to see a claims history on here to understand if we can increase it. But hopefully, for the majority of our listeners, that will cover a great deal of the purchase price.
And if nothing else, it's generate. It's assuming you're buying a property for £2 million. You're reducing your exposure by 50%, aren't you? So it would make sense. Thank you for that. So as far as identity fraud is concerned, then I think there are two things that are significant. Firstly, this idea about knowing your client, I'm going to come on to in a moment or two, but it is important to explain to clients the potential for exposure and to see what their attitude to risk is. You might have some clients that have a very cavalier attitude towards the risk of seller identity fraud and the idea, well, it's not going to happen to me and it doesn't matter, therefore I'm happy to proceed without insurance. Or you might have another client that says, look, I want to proceed with regard to this transaction and to cover every potential angle that you foresee that could lead me to exposure, in which case the policy that Robert's just mentioned perhaps is the fix that ensures that that client sleeps comfortably in their bed at night as the transaction progresses. Again, Robert, just remind me, as far as the fee for that policy is concerned, as I recall, it was a relatively sort of small sum. Can you just remind me, or is it a flat fee, or does it change depending? Perhaps Robert can come back to us. Can you hear me, Robert? We'll come back to that. Anyway, I'll ask Robert before we finish. Other things that I mentioned on slide that I want to talk about. Types of fraud. I've mentioned in the notes corporate fraud. And the interesting point with regard to corporate property fraud is, again, the availability of the use of the corporation or corporations within a family of companies to hide or to complicate sources of funds. In addition to that, we've got the age-old trick of setting up Phoenix companies and false companies that don't have the same company number as the original genuine company, Again, it's important to check transactions. Over the years, I've dealt with a few negligence claims relating to fraud and non-fraudulent activity where a company number hasn't been stated in connection with documentation and information, which has led to confusion and led to claims and problems. Overseas companies, again, verification as to the existence of the company might be important, checking its existence and getting verification from a lawyer within that jurisdiction to confirm the information that's been provided might be appropriate as well. Again, be careful with regard to corporate fraud where there are transactions involving the transmission of property from parent to subsidiary or vice versa. There are opportunities in that situation for inflation or deflation of purchase price, but there's also more commonly an opportunity to sort of switch funds and hide funds, so that when we're talking about sources of funds, it becomes difficult, if not impossible, to ascertain just what money is coming from which company and where that company has obtained that funding. I mentioned in the notes registration fraud, and that really touches on what we've mentioned already about identity fraud. And again, it's important to understand that the Land Registry, to an extent, has been quite cute in attempting to shift responsibility from the Land Registry with regard to seller identity problems to the legal profession. And again, it's important to note that whilst the Land Registry is sort of offering guidance with regard to what steps clients can take to prevent fraud, there's very little guidance out there in connection with protecting a buyer where a seller's identity has been stolen and utilised for fraudulent purposes. Significantly, there are 2 points that I want to make here relating to land registration fraud that I think are important. Point number 1, where you are acting on behalf of an innocent victim who owns registered land that's been subject to fraud and who has, in essence, lost the paper title as a consequence, in order to get the title back, in order to seek rectification of the title to correct the position and address the fraud that is being perpetrated, remember that rectification claims and an opportunity for rectification of a title are only available if it's in the interest of justice to allow rectification, or in circumstances where the registered proprietor of the title consents to the application. So if we're in a situation where a registered proprietor's consent is required, the Land Registry will always look to check whether the registered proprietor of a title has behaved reasonably. If they haven't behaved reasonably, if they've behaved negligently, or if they've participated in the fraud, the opportunity for veto relating to rectification will be lost. So again, things like keeping addresses for service at the Land Registry up to date are so important to establish that the registered proprietor has behaved reasonably, that then provides them with a shield in circumstances where an application is made to rectify their title at a later date. If they can be shown to have behaved reasonably with regard to their ownership of the paper title, then it would only be if the interest of justice permitted it for the title to be rectified and perhaps title or part of a title lost. As far as mortgage fraud is concerned, again, as we've seen from Grondona, as we've seen from other cases as well, there are opportunities for mortgage fraud to be perpetrated. In the case of Grondona, I was just reading a Supreme Court decision over the weekend. That really does show you how sad I am, doesn't it, on a Saturday morning, sitting reading that and taking great delight from it. But in any event, I did. And one of the things that I was interested to note is that the Supreme Court said that there were factors in that transaction that should have meant the solicitors that were acting for the buyer were aware of mortgage fraud. One of which was obvious, the fact that the deposit monies were coming from someone other than their client. Secondly, there was an issue with regard to the management of the property upon acquisition. It was always the view that the property would be managed by the seller of the property, another party to the fraud. Well, again, that would be unusual in a transaction. If a client is buying an investment property, who's going to be looking after it? Who's going to be managing it for you? Oh, well, the seller is. And of course, the other obvious point in Grondona was the fact the property had been acquired by the seller 3 months earlier. and had also been acquired at a third of the purchase price that the buyer was acquiring it. So Grondona is an interesting case for the reasons we're going to examine a little later. It was also interesting because the Supreme Court highlighted a number of factors that should have led the solicitors to regard the mortgage application as being suspicious. And the interesting thing for me is that as a conveyancer, are you really going to be asking a client who's buying a buy-to-let property, who's going to be managing it for you? Well, it's not. It's the sort of question that you would ask. But in circumstances such as this case, it was one of the things that the court sort of identified as an alarm bell issue, which is interesting. Mortgage fraud, I mentioned that there are other factors that will suggest the existence of fraud. Indicators of property fraud in the past have included client contact details being limited, instructions being received by one co-owner or one buyer and an instruction to communicate with the other on a limited basis. The idea of relying on utility bills as evidence in connection with residence at a property. The fact that the seller doesn't live at a property. Information being provided by a client that from different sources that is different. And that's an important point. Again, I can't emphasize enough the idea that client identification verification is not a tick box exercise. There is a need for triangulation. In an old fogey's sort of attitude like me, what does that mean? Cross-checking information and data that comes in. So if I've got a client telling me one thing about their circumstances, is there a way I can cross-check it? I like the idea of triangulation. It sounds a lot better than cross-checking, but hey, I'm very old-fashioned in that regard. Other issues, changes that are being made by the client during the conveyancing process, changing email addresses, changing mobile numbers. And you will have seen, you will have heard of, perhaps even from me, but not bizarre situations where a residential client has changed their mobile telephone number 7 times in the last 14 days. Well, yeah, you know, there might be a very unlucky client who's forever losing his phone or dropping it in the bath. But there might be other reasons that are far more sinister, that alarm bells might ring, and we should be asking or questioning the client. Before I leave this slide, I think there's an important point to make. We're not expected to work for MI5 and have all sorts of measures and countermeasures within the firm to prevent fraud. We are expected to be conveyancers, reasonable conveyancers, doing that which a reasonable conveyancer would do. There is a bit of a health warning that I want to attach to that before we leave this presentation today, but let's just leave it at that at this moment in time. As far as property fraud is concerned, what else is out there? We just don't know. And that's the scary thing. As I mentioned, as we get more sophisticated, as systems get more sophisticated, as we get more reliant on technology, I am absolutely convinced that there are fraudsters out there that are either on the game or ahead of the game and are perpetrating fraud as we speak that we won't know about until all of a sudden there's some news in the Law Society Gazette or today's Conveyancing or elsewhere that warns every member of the legal profession about this new set of circumstances that has led to loss and led to claims against conveyancers as a consequence. I mentioned in the notes a little bit at page sort of 4 and 5 about some points that I just want to touch on that I'll explore a little later concerning due diligence and the idea of meeting with clients and getting to know clients. A failure to meet with a client or a potential client is an issue. And although the vast majority of our conveyancing colleagues may not meet clients these days, it is important to understand and appreciate that that generates a greater risk than sitting down with a client and discussing the transaction or dealing with clients on a regular basis, so that we know when Mr. and Mrs. Jones attend our office, our firm has acted for them on the last 4 or 5 previous occasions, and that this particular firm has acted for these people in the past. As far as due diligence is concerned, technology assists. Modern conveyancing practice to an extent makes life easier, but it heightens potential problems and generates a need, perhaps, for more triangulation, as I suggested a little earlier. In the notes at page 5, I talk about some land registration issues. Do you advise clients, if I was instructing you in a transaction, would you tell me about the land registry fraud line? Would you tell me about their property alert service? Would you tell me about the need to keep addresses for service up to date and the fact that I can have 3 addresses, including an email address? What I always urge practitioners to do is to tell buyer clients about the need to keep addresses for service up to date, perhaps when we're sending the transfer out to the client to sign, but also in our last email or communication with the client as we're about to close our file, a reminder of the fact that they should keep their addresses for service up to date and what they can do to change address. Land Registry would permit a change of address free of charge if the client wants to do it direct. And again, the client should be invited to adopt that approach where necessary, or of course the client could contact your firm to deal with the matter on their behalf. Over the last sort of 12 months or so, I've come across a number of firms that don't tell clients that the Land Registry can use an email address as an address for service, and that surprises me. Of course, it generates another problem because if a client does change email address, it's important that the Land Registry is notified. But in these days in particular, the fact that clients can communicate quickly and effectively via email must be good news. The use of Land Registry restrictions, again, is important. I'm going to show you something later that, again, is really relevant with regard to clients that own more than one property. And again, the Land Registry has provided guidance with regard to the use of restrictions. I wouldn't be telling clients about the technicality of registering restrictions at the Land Registry or about the process, but just simply explaining to the client that it is possible for you to protect them and explain to them what that protection entails. A lot of firms have backed off recommending to clients the use of double L restrictions, and I quite understand why. Because with the double L restriction, in essence, there are 2 problems. One, is it necessary for the current conveyancer to verify ID, or is it necessary for the conveyancer that placed the double L restriction on the title in the first place to verify ID? I'm getting mixed messages from the Land Registry as to what their position is with regard to that. It seems to be that the most common approach from the Land Registry is that the lawyer that placed the double L restriction on the title should verify the client identity, but that creates an additional hurdle and hoop for the conveyancer. I've also seen some Land Registry officers who say, no, if you're the current conveyancer for the client, you can verify ID for a double L restriction purpose. Knowing your client, I think, is important. And again, as far as knowing your client is concerned, a lot of this is sort of old hat, and Dreamvar, Purrunsing and Grondona to an extent have simply highlighted what we already know and what we need to know. The mantra of know your client is frequently repeated by the Law Society and SRA for good reason. But when we talk about understanding and knowing our client, I think we should appreciate that there are 3 reasons why this is important. Firstly, to deal with issues concerning identifying client objective. Now, you will know that I bleat about client objective at every opportunity I get, from christenings to weddings to presentations such as this. I will always highlight to a residential conveyancer or a commercial property lawyer the need to identify client objective, to ask why a property is being purchased. And you might think, well, this is a personal crusade from Ian. Well, no, it isn't, because the SRA have highlighted on a number of occasions the fact that we should be identifying from a client the purpose of the transaction. So asking the client what their purpose is with regard to a purchase is exactly the same thing, in my view, as verifying client objective. So we've got to know that, and to do that, to ask that question, we're finding out about our client. We're getting to know our client. In addition to that, we are also, of course, obliged to identify what our client is, who our client is, for compliance purposes. Obvious. But I think the next point is something a little bit more subtle and a little less obvious, and touches back on a point that I made to you earlier. about risk knowledge, or the acceptance of risk, or the willingness to take risk. So if I instruct you in connection with a transaction and you tell me about identity fraud or seller identity fraud, am I sort of very happy just to proceed with the transaction in the knowledge that there is this very remote risk, but it's the same sort of risk as there might be with regard to being struck by a meteorite or something of that nature? Or am I absolutely terrified and immediately insisting that you ring up Robert Kelly and his colleagues to obtain an indemnity policy to protect me in the event of this exceptional circumstances arising and me sustaining loss? Very interesting that when we were looking at lockdown, when we were dealing with lockdown, one of the things that we were frequently sort of being met with was the Law Society emphasising that because lockdown was an exceptional situation, caution needed to be exercised in explaining to clients risks associated with limitations on the conveyancing process relating to lockdown, and highlighting that we might have inexperienced clients or vulnerable clients. And again, the same principle applies, I think, with regard to fraud. If we've got a client that's regularly buying and selling property that we've explained to in the past about the risk of fraud, is it necessary to sort of dwell on that and to go further into it with regard to the current transaction? Probably not. If we've got a first-time buyer, if we've got an elderly client that we know and is very sort of shaky and concerned about the conveyancing process, the position might be different. I mentioned on slide here the issue of onboarding clients. And again, the important point with regard to this is when we are onboarding clients, there are questions that we should be constantly asking. Why is our client instructing our firm? What is their objective? What is their relationship? What is their view as to risk? I think there's another question as well that we should be asking the client when we onboard them, and that is asking them about their knowledge relating to the conveyancing process. Are they aware of the process? Are they not? Should we be explaining to clients the bigger picture with regard to the conveyancing process so they can understand and appreciate perhaps more their potential vulnerability? Final point, and the final word of caution here with regard to onboarding clients, is something that I think a lot of firms are currently overlooking. With regard to my consultancy work and training work, I'm encountering firms now that will have specialist teams that deal with onboarding. And those teams may not necessarily be fee earners at all, and may not be the fee earner that will actually be dealing with the transaction. And the important point that I want to get over here is that the SRA have suggested, and the Law Society have suggested frequently and regularly, the fact that it should be the fee earner that is undertaking the appropriate checks when the client is onboarding to the firm. And that's something just to watch out for. Just reading something recently where the idea of a support staff or receptionist onboarding clients was potentially dangerous on the basis that they were not aware of the duties and obligations that were owed as a conveyancing professional in connection with the onboarding of clients. I mentioned the idea of checking corporate clients and making sure that we understand and appreciate the status of the corporate entity that's instructing us and the individual that's instructing us within that organization or entity. And I mention also in the notes and repeat this problem with regard to the layering of funds when we're acting for buyers. Just what is the source of funds in connection with intergroup activity? Moving on, if possible, we've asked these questions already about why our firm has been chosen. Again, check it up. So if a client comes in by recommendation, check the person that's made the recommendation. Where our client has an objective with regard to acquisition, so it's a buy-to-let property or something of that nature, are we satisfied with regard to that objective? Whether or not there are any further questions that we should be asking. Remember, in Grondona, an investment property, had the question been asked who is going to be managing the property, and had we found out that the seller was going to be managing the property on the buyer's behalf, that connected with other issues particularly the issue that we're acting on behalf of the seller as well as the buyer in that case, should certainly be ringing alarm bells in our ears. Electronic verification of clients. Again, great news potentially, okay? The idea of the opportunity for a third party to do this verification for us in a sort of fail-safe manner, what's not to like? We can verify who is the client by a myriad of amazing systems and processes. There are a number of problems that flow from that we need to check up on. And one of the things I think that is important is to ascertain which process our firm is using for electronic verification and to make sure that we've got a paper trail with regard to the use of that system, so that we've got evidence that we've undertaken a due diligence exercise with regard to the provider and the system that's used. And again, one of the things that I see throughout the references and materials relating to electronic verification is the need to still bear in mind that triangulation or cross-checking could still be important. So again, it really touches back on the point that I made a little earlier, that client identification, electronic verification is not a tick box exercise. We've got a pass with regard to electronic verification system that confirms the client is who they say they are. Well, that isn't the end of the story. There may be information that we've got about the client that might challenge that or question it, or might warrant questions or challenges that we ought to make. I said at the start of my presentation that what we'll be doing today is having a look at Dreamvar, Purrunsing and Grondona, and just having a look at where we are today. And there are a number of points really that I want to make at page 8 of the notes going forward. And the first question I ask is, does Dreamvar, Purrunsing and Grondona change anything? And in short, I don't think they do. I think all they did is highlight awareness, perhaps make practitioners aware that we're more vulnerable than we thought we were, but don't come up with any sort of magic fixes other than one or two of the points that I'm going to make now. If we look at Dreamvar to start with, I think Dreamvar highlights and fires a warning shot against any conveyancer acting for a buyer, asking the seller's conveyancer to verify their client's identity. We shouldn't be asking for warranties. We shouldn't be asking for any form of confirmation with regard to seller's ID, other than perhaps that the appropriate AML checks have been undertaken. That should be as far as it goes. Because if we do ask the question, we're saying this is a live issue for us and our client. When we get the rebuff that we could expect from the seller's conveyancer, no, we're not prepared to provide it, etc., etc., we've then got a problem, because we're saying to our buyer client that there's an issue here that we want to try and deal with and close off. We've been unable to deal with it and close it off, and therefore what do we do? Well, what I suggest to practitioners in those circumstances is our email to Robert and colleagues, or a telephone call to Robert and colleagues, or an online application to Robert and colleagues relating to seller indemnity insurance policy. I was reading something that was quite interesting again over the weekend about this very point. And what someone was saying, I think this is a really good point. Let's assume that all of a sudden there's a standard form of warranty that a seller's conveyancer gives relating to the seller's client's identity. So let's assume from a buyer's perspective that, hey, all of a sudden there's a change in attitude with regard to warranties, perhaps the conveyancing protocol alters, and therefore every seller is now obliged to give that warranty. Well, the point in this article was, well, surely in those circumstances, the value of the warranty is eroded on the basis that it's just accepted that that warranty is given. And in the circumstances, it might be that the seller does not, in fact, undertake additional checks or do anything. What this article was saying is that that warranty, or warranties of this nature, should only be provided in exceptional circumstances. And where they are provided because of a genuine need within the transaction, then the warranty has validity and potentially has more enforceability as a consequence. An interesting point that I hadn't thought about. The other point was that the Law Society's code for completion by post generates liability for the seller's conveyancer potentially, and therefore again erodes the value of warranties, assuming warranties were provided. So I think as far as Dreamvar is concerned, there's little to be gained from the case other than a heightening of awareness relating to fraud generally. And I think the other big point from Dreamvar, which is bad news for conveyancers, where a buyer client is sustaining loss as a consequence of identity fraud or property fraud, the lawyers that are acting for the parties, the buyer's lawyer in particular, has a very healthy, has a very juicy professional indemnity policy that is sitting there in the background to ensure that if the buyer client sustains loss that is irrecoverable elsewhere, the loss can be recovered from that policy. Now, of course, I suppose the policy issue here, policy in the sense of the bigger picture, is that the availability of a professional indemnity policy in connection with the conveyancing firm is a comfort blanket for buyers. And it means that the conveyancing process and the current process as is attractive to buyers as a result. I get that. But as far as Dreamvar is concerned, what else has changed as a consequence? Well, we have the Law Society's code for completion by post being carefully scrutinised and altered, but not much more. If we then turn to Purrunsing, what do we extract from that? Well, again, the points I've made. Client identification, verification is not a tick box exercise. It's an ongoing process. Secondly, and significantly, and I think this is something to take from Purrunsing going forward, cumulative incidents, which of themselves are of no consequence, should be examined in the round and in context. That there is, after a while, where we're being dripped information or misinformation about a seller, or indeed a buyer's conduct, or indeed about a mortgage application or anything else, there comes a point where the net effect of all of those incidents is such that we have an incident that requires notifying to our compliance team, or at the very least a discussion with a colleague to see, hey, you know, I'm now a bit wary, things have been happening in this transaction that just don't seem to be right. As I sort of rather unfortunately call it within the notes, the sort of sniff test that should be used. And I think the other thing is that in Purrunsing, we sort of get a flavour of the court saying to us that not all clients are the same. So that the idea of standardising the conveyancing process is great. The idea of case management systems, etc., is absolutely brilliant. But at the heart of the conveyancing process is a client, and client's needs, demands, etc., vary from client to client and transaction to transaction. And I think that's an interesting point generally with regard to the conveyancing process. As we're standardising our communication, standardising reports on title, there's a danger that we lose the fact that this is an individual whose requirements, whose needs, whose expectations are different to the last client that we've filed, whose file we've just opened and dealt with. I do a lot of work at the moment with regard to reports on title in conveyancing transactions and the idea of a standard form of report on title, which is a great thing from the perspective of bringing claims against conveyancers. If we have a template that we use, a template that is populated automatically from various resources that we're able to access, that has to be good news. But at the end of the day, it isn't good news on the basis that every client is different. Every client will have different objectives, different needs, different expectations, different levels of understanding. And therefore, there is a need to taper or temper standardization and to ensure that, yes, we're using the advantages and benefits of a standardized conveyancing process, standardized documentation, allowing us to spend more time on the sort of soft skills with regard to the client, making sure we're doing what the client wants us to do and making sure that we're drawing to our client's attention key points and issues relating to the transaction. From Grondona, what can we learn? We're going to look at the case in a little more detail before we finish, but one, of course, there's an inherent risk in acting for a seller and a buyer. And I felt heartily sorry for the solicitors in this case on the basis that they didn't look particularly impressive before all courts in this sort of sorry tale with regard to their willingness to act for a seller and buyer in these circumstances. The case also highlights again a basic conveyancing point, that we verify the status of the seller with regard to the periods of ownership and purchase price that was paid, and warn our client and lender if there are suspicious circumstances in that regard. And of course, the big point with regard to Grondona, criminality of the client won't exercise a claim in negligence, as we'll see in more detail. Moving on, if I can, land registry advice. We've covered most of this, to be honest with you, so we can skip along if that's all right. But the land registry has said that the clients can be categorized into high-risk clients where there's been a history of identity being stolen, where they're renting out the property, where they're resident overseas, when they own empty property, own and mortgage property, or own and registered property. There's a request that clients to sign up for property alerts, and that property alert system enables alerts to be given to the client for 10 properties within their ownership free of charge. Clients can also put a restriction on their own title free of charge if they don't live at the property. I've already mentioned the inherent danger for conveyancers with regard to double L restrictions, so I won't go any further with regard to that point. Case law, let's just have a look. Remember earlier, before you all were upset with me going on about gloom and doom in connection with property fraud, for which I apologise, I said that we have to be careful about the Law Society's conveyancing handbook. Why did I say that? Well, I said that because of this fairly old case now, 84 decision, Edward Wong Finance and Johnson, Stokes and Masters. The court said that when we're looking at negligence claims, the fact that we've complied with the recommendations or advice given in the Law Society Conveyancing Handbook will normally confirm that we've behaved as a reasonable conveyancer ought to behave, but the court might decide, notwithstanding full compliance with the handbook, that as conveyancers expose the client to a foreseeable and avoidable risk, which would amount to a breach of duty of care. Then we've given Purrunsing, which generated equal liability for 2 firms of licensed conveyancers acting for seller and buyer. Seller's conveyancer not being alive to the fact that their client was doing all sorts of weird and wonderful things that should have sent alarm bells ringing. Buyer's conveyancer asking a question about verification of client identity of the seller's conveyancer and not getting a satisfactory response. And Dreamvar, again, of course, the point that I mentioned to you earlier about the fact that we have a situation where a solicitor's professional indemnity policy created a fix where there was no other fix available to an aggrieved buyer that lost out as a consequence of fraud. I am conscious of time, and I'm conscious of the fact of wanting to build in time to enable us to deal with questions. And therefore, I have mentioned in the notes, and I want to finish today with my notes at page 13, and the case of Grondona and Stoffel. Very interesting case this, going back to 2002, a purchase of a property, and the situation was that the seller of the property and buyer of the property instructed the same firm of solicitors. Mortgage advance acquired by Miss Grondona was fraudulent. She'd misrepresented a number of things on her mortgage application. Firstly, she hadn't made the lender aware that this wasn't a private sale. She had lied about deposit monies coming from her own resources. She'd also lied or failed to advise the lender that the property would in fact not be managed by her, but would be managed by her partner in crime, namely the seller of the property. The interesting thing with regard to this case is that our solicitors that are acting for both buyer and seller then get things dreadfully wrong with regard to registration of charge and registration of transfer. The Miss Grondona, the buyer of the property, lets the side down by not paying her mortgage and defaults on it, leading to possession proceedings by lender when the whole sorry tale is exposed in its sad state to everyone concerned. Lawyers can't argue that they weren't negligent. Clearly they were in failing to register charge and in failing to register transfer. Their illegality defence was an interesting one. Well, yeah, we weren't very good conveyancers and didn't put ourselves in the best light in connection with this transaction, but we've got to get out of jail card or a get out of a claim card on the basis that this was an illegal act. Supreme Court has a look at it and says another number of interesting things, really. Firstly, well, let's think about this. If we say that illegality in connection with mortgage fraud or other fraud in the conveyancing context would mean that if a conveyancer has been negligent, they escape liability. What message are we sending if we allow that? Are we going to have fraudsters sitting out there at their computers thinking, let's not do mortgage fraud or property fraud anymore, because if we instruct the wrong firm of solicitors who get things wrong, we don't have any right form of redress? Does that mean everyone is now going to sort of say, right, let's close all our activity with regard to property fraud and let's find someone else that we can undertake fraudulent activity from that will be a lot easier? No. And the second thing is, is it right that conveyancers can think to themselves, well, we needn't necessarily maintain the high standards that's expected of us, because if there is fraudulent activity relating to a transaction, we're not going to be liable. So there's lots of policy factors, I think, sitting behind the Grondona decision. From a legal perspective, one of the interesting points was that the fraud was perpetrated with regard to the mortgage application. The negligence arose after completion with regard to failure to register. There was no connection or nexus as between the two. Very interesting point. I've given you lots of detail in the notes relating to it, but I am conscious of time, and I'm now looking forward to my very favourite part of all of these webinars, Stephen, and that's the question session. So if there are questions, Stephen, I would love to receive them. If you can sort of filter or share with me and delegates what those questions are, that would be brilliant. If there are any queries or questions relating to anything that we've said, there are email addresses shown on the slide there that will enable attendees to either ask Robert for information about Stewart Title product, be it seller identity product or anything else, and there is an email address for me for any questions or queries that people have that are they're too shy to raise this afternoon or this morning, and can be raised at a later date.
Well, that just leaves me to say, on behalf of Stewart Title and Ian Quayle, thank you for joining us today and have a great rest of your day. Thanks everyone and goodbye.